Hey, it's Bernard Nomberg with the Nomberg Law Firm. And one situation that comes up quite a bit in our cases is the scenario where the injured worker has gotten the return to work paperwork by the authorized work comp doctor, and they attempt to go back to work, and the employer puts them back at a job that exceeds any of the restrictions or some of the restrictions that are on the return to work paperwork. For example, let's say that the injured worker has a return to work in a light duty capacity, but the worker is employed by a construction company, and there's no job out there at the construction company that has a 25 pounds limit. So the employer in this situation says to the employee, all right, here's the job. The job is lifting things that are in excess of 25 pounds. Let's say it's 50 pounds. What is the employee supposed to do? Because the job that they're being offered, it goes beyond what the doctor's opinions are at the current abilities of the injured worker. Well, there's really three things that can occur. One, you hopefully are under the good enough relationship with the employer that the employer is really frank with you, where they're able to find a job to accommodate you, because hopefully this light duty restriction is just temporary. And if that's not the case, if the employer says, all right, here's the only job that we have, well, it may be that your lawyer needs to be involved in getting with the insurance company, because the employer cannot accommodate them, that maybe they should not be at work at this point in time, and that work comp benefits should continue because the injured worker can't go back to work. Secondly, you can go back and talk to your doctor to confirm that those in fact are the lifting restrictions or the light duty restrictions. We would never advocate you changing that, because you have a professional medical opinion stating what they think the opinions of your abilities can be at this point in time. Hopefully that changes and that you go back to full duty or a heavier duty restrictions later on. And the third option is that you have to look for potentially for other employment elsewhere. And it does get a little complicated. There's a little more involved than this, but this is a real life situation that we deal with quite a bit, because it's the doctor's professional opinions may not mesh with the current needs of the employer, and that puts the injured worker right in the middle. We deal with it all the time. Call us at 205-930-6900. Nomberglaw.com is our website. You can also find us on YouTube, Facebook, and Twitter.